Hi, my name is Sabina Bubber. I'm a mortgage broker with Ziva Mortgage at divorce.mortgage and also sabinabubber.ca. Today we're interviewing Nikki Charlton, who is a partner at Ferris LLP, where she specializes exclusively in the area of family law and provides services from either a collaborative or a litigation approach, depending on the individual needs of her clients. She's an accredited family law mediator, arbitrator, and parent coordinator. Nikki was named Lexpert's Top 40 Under 40 Lawyers in Canada in 2015. She's an exceptional litigator and an astute deal maker who is effective at keeping high-profile clients' business out of the news and finding tax-effective solutions to settlements involving complex corporate structures and trusts. Thank you, Nikki, for coming today, and I'm just so honored to have you here. Thank you.
Thank you so much for having me, Sabina.
So Nikki, a lot of my clients have asked me questions knowing that I've been through a divorce. What are some of the options for people that are going through a separation, and how do they start to find a professional? What are the options available to them to find the right path for them?
That's a very good question, Sabina. I think for most people, going through separation and divorce is one of the biggest challenges that they're going to ever face in their life. And the most important thing is to have the right team behind you and make sure that you know what your rights are. And if you have children, to remember to put their best interests in the center of any dispute. As far as process goes, it really depends. Most people go into separation and divorce being completely overwhelmed, not knowing where to turn. I would say the most important thing is to talk to your friends who have gone through it, find out who they worked with and who they would recommend. Referrals, as you know, are our life's work. And if you do a good job, or if I do a good job, the community will know that. As far as process options go, ideally, you're going to stay out of the courtroom. Especially with COVID and the pandemic, our courts are just overwhelmed with people trying to have their cases resolved. It is months, if not years, before a final resolution. And that, we're talking thousands and $10,000s of dollars in legal fees. And more importantly, the emotional toll that takes on people and their families. So in a perfect world, everyone would be doing collaborative work, meaning you each have your own lawyers, you work together as a team, you may have coaches to help you with parenting issues, you may have a financial specialist if you were not the person who was involved in the inner workings of your financial world in your family. And you build this team and you work together in four-way meeting settings and you get your deal done. And at the end, you have your separation agreement and your parenting plan, and life goes on as sure as the sky. The other end of the spectrum is litigation. Litigation, of course, is where you're filing a notice of family claim and you're going down the path of often fighting in court, unfortunately. Now, litigation doesn't have to be horrible. It's just another process option. And most people are afraid of that process, but really it's just a way to get people moving. Sometimes at the beginning of a case, I'll send a letter to a husband or a wife and I'll suggest, my client really wants to do this in a collaborative way. Will you please retain a lawyer? Here's a list of all of the names of the lawyers who practice in this area. And silence. We don't hear anything at all. So you follow up, you try really hard, you talk to your client about how they can talk to their partner about process options. And sometimes people are so overwhelmed that they're paralyzed by the process and they don't do anything. In that case, we start the court action. And then typically what ends up happening is we're in a process that has deadlines and the person comes to the table. And then from there, we can either do the collaboration part or we can go to mediation, which again, you have a third party helping the parties reach an agreement, which is very helpful. Or you can go to arbitration, and arbitration is where you have essentially a private judge. So lots of different options, and there's really just a continuum, and people sort of move along that continuum depending on what their needs are and whether there are disclosure issues, whether there's family violence. And there's so many issues to consider in every case. And so my first interview is really where I gather all of the information I need to help the client determine which process option is going to work for them.
And so what happens if somebody decides not to disclose? If they're not necessarily intentionally not disclosing, let's say I've often heard partners or women have come to me and said, oh, my ex hasn't produced his financial documents yet, so he hasn't filed his tax returns in 2 years. So we have no idea what the eligibility is for division of assets, payment of child support, and that kind of thing. How do you address those issues?
So number one, a non-disclosure is what we describe as the cancer of family law. And if you're in front of a judge and you have not disclosed your tax returns, all of your assets, all of your debts, you're in for a world of hurt. There are fines that could be issued against you. There are sanctions. Unfortunately, of course, that requires you to go to court, which is expensive. If you're in the collaborative process, you're actually signing a participation agreement, which requires full and frank disclosure. And it's often in that forum where you're not cross-examining someone, but you're really having open and frank discussions about what kind of documents we need and the fact that they have to be disclosed. And our rules of court, rather, whether you're in litigation or you're in collaboration, the rules apply to everyone. So if you have someone who doesn't want to disclose, like if you came to me and you said, hey, Nikki, I don't want to disclose my tax returns, I would say to you, you're not going to have an option. That's required at law, and either I'm going to make you disclose, and if you don't disclose, I'm not going to act for you, or the courts will make you disclose. Yeah. And again, the key is making sure you build a team where everyone's on the same page and recognizes that disclosure is required. I mean, every once in a while you get the person who just refuses to cooperate, and those are the cases that end up in litigation. And unfortunately, there's nothing we can really do but use the resources that we have in court.
And if you've got say a partner that's been at home for 30 years and she doesn't have the resources to get to court and her ex-partner won't necessarily do that, what are the options for people like that?
So if you have a stay-at-home mom who, say, for example, didn't have any involvement in the finances, doesn't know what's there, can't get disclosure, doesn't have any access to money, there are rules that are available to them to be able to apply to court to get an order requiring a lump sum for legal fees, so that they feel like they have the resources that they need to be able to fight if they have to. So not everybody knows that those options are out there, but they are. And frankly, if someone doesn't want to disclose, it's really a call to the other lawyer to say, are we really going down this road? Yeah. And there is the Form F8 financial statement, which is a sworn statement of property and debts and income. And if you're lying on that sworn statement and it's found out, your credibility is shot. And like us with our reputations, your credibility is all you really have in a courtroom.
What are some of the most common issues that you come up against in family law cases?
That's an interesting question. I mean, the law has changed, and we now have the Family Law Act. The difficulty with the Family Law Act, and as it relates to property division, is we now have what's called an excluded property regime. So what that means is you need to go back to when you first started living with someone, and you have to determine what were my assets and liabilities at that time. And so everyone going through this process who comes into my office, it's always sort of the same set of questions. Okay, you started living together 10 years ago. What did you have? And so you may say, well, I had a condo on Quebec Street in Vancouver, and there was equity in that of 200,000. And I say to you, okay, well, you sold that property 5 years ago. What did you do with that money? And you say, oh, I bought another property with my 300,000 because it increased in value, and I put it into this next property. So excluded property means, what did you have at the beginning? Can you trace that through to the date that you do your deal or there's a trial? And so that's one piece. And I know there's a piece around inherited assets as well. So if you receive gifts or an inheritance from a family member, then that's also what's called excluded property. And it's only the excluded property, and then it's the increase in value that's divisible with your partner on separation and divorce. Now, that may sound all well and good and simple, but family law, we live in a world of gray. And that concept of excluded property can be lost. And it really turns on the facts of each case. But let's say, for example, you had excluded property, you put it in a house, it was in your sole name. You take that house, you sell it, you then buy a new property and you put it in your husband's sole name because he's an entrepreneur and you're worried about creditors. Well, have you lost your exclusion as a result of that? So nothing is black and white, and that's why for most people, I would recommend having a cohabitation agreement or marriage agreement at the very beginning of your relationship. At the very least, gather up your statements, your bank statements, your investment statements, and make sure you just tuck them away in a file folder so you know 15 years later, in the unlikelihood of divorce, which these days is not actually that unlikely. We all know what the divorce rate is, and it's not low. At least you have that information there. So you can say, actually, 15 years ago when we started living together, this is what I had. And you can protect, hopefully, the assets that you brought into the relationship or any gifts or inheritance that you received.
How should somebody prepare for a meeting with a family lawyer? What do they need to know before they go to that meeting, and how do they what documents should they gather, and how do they best capitalize that on that first meeting to get their biggest bang for their buck with information that they'll come away with?
Okay, very good question. So the perfect client for me is one who comes into my office for the initial meeting, and I have a paralegal, Doreen Rule, who we work together as a team, and she's exceptional. We've been together for years. And typically she's the first person that you'll talk to before you get into the door. Not everyone gets in the door. I've got a long wait list, and really it's a fit. I mean, like everything we do in life, some people should go with someone else. It's all personality. It's all that feeling of just, I can really help this person and get them through this. And so first point of contact is Doreen. And she'll usually say to someone, make life easier for Nikki and for me. Put all of your information in a binder for us. Put it in a folder. In a perfect world, it would be bringing your 3 most recent tax returns, if you're incorporated, your financial statements, and then really a snapshot of your financial world. So here's a list of my assets. Here's a list of my debts. So that's really the financial piece. We haven't touched on parenting. One of the most difficult areas of family law has to do with separation and divorce and its impact on children. And, I'm a real believer that children are part of both of their parents. They're 50% of each, and nobody's perfect. In a perfect world, children would be equal with both of their parents. That's not always the case. Children have their views, they have connections with their parents in different ways. Younger children require different types of parenting plans than older children. So when people come in, it's really twofold. It's the financial matters, and then it's the issues concerning children. And there's no presumption of 50-50 parenting in our province, but all things being equal, we want meaningful relationships for children with both parents wherever possible. And so usually we'll talk about those issues. It's so hard to not see your kids whenever you want to see your kids. I mean, I think that's probably one of the most difficult parts of separation, is that you have children and you expect you're going to be able to see them whenever you want to. And then all of a sudden, someone tells you, whether it's a judge or your partner's lawyer or whatever the case may be, that no, sorry, you only get to see them every other weekend, and I think you're a horrible parent. And I think that you drink too much on the weekends, and I think that you don't always have their car seat on properly. Like, the things that people say can have huge impacts on children. So I do a lot of parenting type work. I'm a parenting coordinator, so I help families who are typically high conflict to find ways to manage their children post-separation and divorce. So when people come in, I try to really separate, what do you think's best for your children? How old are your children? What kind of parenting schedule should we implement? And then I do the money matters. So that's really the first interview with me. And then I tell people the lay of the land of, okay, did you have excluded property? If you did, if you received a gift from a family member, bring in the documents you have relating to that gift. If you entered into a cohabitation agreement or a marriage agreement at the beginning, obviously bring that document in. If it's a review of child support or spousal support, bring in your separation agreement. So anything that you feel may be relevant to your family law case, I will need to know about. But the first meeting is really just me understanding the story and, wherever possible, the perspective of both spouses, if that's possible.
During the parenting coordination process, at what point do the children have a say? Is there a specific age in the eyes of the law, or is it flexible? How do you decide when, if the child says at 8 years old, at 9 years old, I just want to stay with mommy because that's where I'm comfortable, or I just want to be with daddy because I bond with daddy more? When is there a specific cutoff? How do you handle the children's voice?
It's tricky because every child is different. Their maturity level is different. In my experience, I would say those children sort of 12 and up, their views really start to more come into play. By the time a child is 14, 15, you see them often voting with their feet. So you can have an order that says, it's week on, week off, and then you'll have a teenager who says, you know what? I'm really busy in school right now. I can easily focus at dad's house, so it's more quiet. I can get my schoolwork done. I want to spend time with dad during the week so I can really focus on my homework. And mom's house is more social. She's got that downstairs room for me to hang out with my friends, so I'd rather be there on the weekend. And that really makes sense. And so you really have to take a look at what's best for these children. Of course, meaningful relationship with each parent, but as they get older, their views and their needs change. So you may have, a young child who regular parenting time with each parent is important, because of course, children when they're 1, 2, 3 don't have that ability to determine, when was the last time I saw mommy, or when was the last time I saw daddy? So that regular, constant contact with each parent is important. Mm-hmm. As children get older, they can handle more separation from each parent. But again, every situation is different. If you have a child whose dad traveled all of the time and never spent time in the home, and then all of a sudden dad wants to be the primary resident parent, that's going to impact a child regardless of their age, because that's a huge change from the status quo. Mm-hmm. And so where it may be best for them to have equal parenting time, maybe that transitions over a year or over 2 years. And really, from my perspective, those kinds of issues they're not really legal issues. It's looking at a family dynamic and saying, what's the best outcome for success for these children? And that's really what we should be doing. The money, the complicated trust, the financial issues, those are separate. And one of the questions I knew you were going to ask me is, how do I know what to ask my lawyer versus what I should ask my therapist? Because lawyers are not cheap.
Yeah.
And you get what you pay for. And counselors are exceptional when it comes to emotional issues, managing expectations on a number of fronts. And so if it has to do with legal rights and division of assets, those sorts of things, of course, gather all of your thoughts, come to me. If it has to do with, I'm just so mad that he didn't drop the dog off with the kids and the diaper wasn't changed or this happened and it's more emotional, that's where you should go to your counselor or your parenting coach and say, how do I navigate this? How do I talk to my spouse in a way that he or she will actually listen to me and hear me? Because that's a huge part of this. Parents have real difficulty hearing the other one. And because of their history, their triggers, all of those things. And so learning with the help of an experienced divorce coach or a counselor can go a long way with managing emotions and getting through really what is one of the most difficult times in a person's life.
Now, earlier in the conversation, you were talking about cohabitation agreements and marriage agreements. What kind of things generally do those agreements protect you from? They protect you in division of assets, but do they allow you to exclude yourself from being required to pay child support or spousal support down the road if you wanted to agree to that in advance?
So, yes and no. What you can do in a cohabitation agreement or marriage agreement is set expectations. So on the property division side, the reason I really like cohabitation or marriage agreements is because of our excluded property regime. People often lose documents. You can't actually go back more than 7 years at banking institutions to request documents. So I like cohab and marriage agreements on that front because it actually sets out what each person came in with. And that way, even if you've decided, I want the law to apply to us when it comes to excluded property, meaning what I brought in is mine, any gifts I receive from a third party, like my parents or inheritance, is mine, and it's only the growth that's divisible, and we're going to trace it through. Even having that sets the stage for what's the outcome in the unlikely event of separation and divorce. With respect to child support is the right of the child. It is very hard to contract out of child support, but you can be creative. You can set upper limits or bottom limits, caps really, on what income level should be used for child support, or you can try to. For spousal support, you can say, listen, we've both come into this relationship with decent income. However, if I decide or you decide that we're going to stay home and raise our children, if we're going to have children, then the agreement to not pay spousal support goes to the wayside if we have children. So you can contemplate all of those material changes and circumstances right in your agreement, which means you can say, provided we don't have children for the first 10 years of our relationship, there's no ability for either of us to seek spousal support from the other. Yeah. But if we do have children, you can ask for spousal support, but then we're going to include these caps. Or for every year we're together, that only means there's an obligation to pay support for half the year. Like, there's so many ways. It's like a choose your own adventure. and you create this document based on what each person's interests are. And that's the key to success, really.
In that process, do you each have your own lawyer representing you to make sure that each person's, so same as if you're getting divorced, same as the same thing going into that relationship?
It is. And a couple of things there. Number one, nobody likes to talk about, listen, I want to protect my assets in the unlikely event that we separate. But it's the practical reality. Do you really want to spend tens of thousands of dollars in legal fees having a fight? Or do you want to spend the money up front to know what you're entitled to at the end of the relationship, depending on the various circumstances? So a cohabitation agreement, a marriage agreement, from my perspective, is key to success in these situations.
Yeah.
And they're not that expensive. They can be complicated if you've got family trusts and a whole bunch of different asset base, but really it's that conversation of you need independent legal advice. Both of you need to have lawyers, absolutely. And full disclosure is required. If you don't have those two things, it's a big problem. And you also need to make sure that nobody's feeling pressured. Your marriage isn't happening in 2 days. You're not 9 months pregnant and someone is saying to you, you need to sign this agreement before you have your C-section on Saturday. Those sorts of things.
I've heard a lot of people talk about, we went to mediation. So exactly what does that mean when you go to mediation? Are you there with just a mediator, or do you have your own lawyer and your partner, soon-to-be ex-partner is also have their lawyer? How does the mediation process work? And is that cheaper than court? Well, how do you get to mediation?
In a perfect world, both parties will have a lawyer at mediation. Mediation is really just a way for everyone to come together and to focus on getting a deal done. People are busy. Lawyers are busy. People who come in to see you, your clients are busy. So sometimes you end up circling the drain. And what that means is there's letters going back and forth between lawyers. Oh, what about this? What about that? And you may have offers for settlement going back and forth, and you just can't quite get a deal done. So, or people are so busy that they want a mediation date in the calendar so that they can have a date to work towards to get the resolution done. So they make sure all the financial disclosure happens in advance. They get the parents working on a parenting plan, maybe off to coaches. And then most mediations are shuttle mediations. So what that means, if you were my client, then you and I would be in one boardroom, and your spouse would be in a boardroom with his lawyer. And then the mediator, who you jointly retain, goes back and forth. And what they're trying to do is find the sweet spot for a settlement. So they're thinking about what your interests are. They're thinking what your partner's interests are, and they're looking at the law as it applies to your facts. And I typically like to go to mediators who are more evaluative. So they will be in the room with you and they'll say, well, that's great that you're taking that, position, but that position's not tenable at law. Or they know what your husband's interest is, and maybe his interest is, I really, really want the parenting schedule to be Mondays and Tuesdays, and you always have Wednesdays, Thursdays, because I've got all my work meetings on certain days. And so they'll know what's important to each person, and they'll try to find a way to do a deal that meets as many interests as possible of each of the parties. And then typically what happens is right then and there in the mediation, and sometimes they go until 10, 11, 12, in some situations like 3 a.m, but I try not to let that happen. What you do is you have your settlement document. You work on a separation agreement or minutes of settlement, or if you've started a court action, a consent order. So you're working on that so that at the end, you're signing your deal and you're done. And all you have to do is the steps to implement the deal when you walk out the door. And if you had been married and you want to get divorced, then the only other step would be the uncontested divorce application, which is not difficult to accomplish. And so, yes, it's hard. You're spending, 8 to 12 hours in a boardroom with your lawyer, which isn't always fun. But at the end, you've got this paper that documents what your obligations and your rights are for moving forward.
When you talk about costs, when it comes to mediation versus court, how would you say the costs are in terms of is it a fraction of the cost to go mediation versus court because you're settling everything in that one day versus going back and forth for months between lawyers? How would you say that runs on a cost basis?
So again, disclosure is key. So provided you have full disclosure and you know what you're dealing with asset-wise, going to mediation, number one, you're choosing your mediator. And I have, probably 6 mediators that I have built relationships with and who I go to and I trust. And you can get into a mediator within a couple of months. The difficulty with proceeding to court, of course, is there's a lack of judges. You think you're getting on for a trial or an application only to be bumped. And so what ends up happening is your lawyer prepares, and often there's affidavits, like sworn statements that are made, which take a lot of time and effort to prepare, which isn't necessary for mediation. Maybe you've done a mediation brief and exchanged your financial disclosure and offers. That's not a process as arduous as preparing for court. And you're in control. You're in control of that process. It's strictly confidential as between you and your partner. Everything you say is without prejudice. As soon as you're in a court forum, unless you've obtained an order to keep the file sealed or keep it private, which is very hard to do, it's public. And anyone can come in and sit in chambers and watch your life unfold. And you're leaving it to one person who may not have ever practiced family law, that being the judge, because we are a generalist court, determine the outcome of your life after either you're giving evidence and have witnesses on a stand or on affidavit evidence. And if there's anything I can tell people is that you want to be in control of the outcome of your life. And mediation or collaborative practice really are the ways to be in control. And sometimes I'll do what's called mediation arbitration, where you go to mediation, you are able to settle 4 out of 5 issues, but there's, one issue that you can't resolve. And so you'll deal with that one isolated issue in what's called arbitration. And that's where you have essentially your mediator, who could also put a different hat on and be the arbitrator, to decide that issue. And they apply the law. And then again, you're avoiding having to go to court, having to wait. And it's so frustrating because it's emotionally charging for people, obviously, to go to court. And it's emotionally charging for the lawyer because we're advocating on your behalf. We're putting all of these materials together. You're waiting to be heard, only to be told, I'm sorry, there's only 3 judges today and you're not going to be heard. So then you have to start over. And you're paying for a lawyer's time, and that time doesn't go away just because you didn't get heard. So there's just so much to be said for out of court processes. And that's not to suggest it's not an option, because it is. I mean, I go to court regularly still, but it's typically on those cases where there's no other option. It's like, where's our child going to school? It's either A or B, like there's no middle ground. Or a mobility case, you want to move to South Africa and your spouse wants to stay here. Well, where's the middle ground? You're either moving or you're not moving. But rather than proceed to court, you can do that privately with an arbitrator, and you can choose your own rules that apply to you, whether it's the Arbitration Act or whether it's the family law rules of court. Like, there's so many options available to you.
How does one find out if they're eligible to receive child support, and how do they find out how much they have to pay? Is there an easy way to do that without going to a lawyer?
Yes and no. Sorry. There's two elements to child support. And the first piece is to determine where are your children living. And then everything sort of flows from there. And then that's step one. And step two is the determination of income. If you have someone who's incorporated or self-employed, if you're incorporated, you have to lift the corporate veil and see what's going on within the corporation. Because if I only need $200,000 to live, but I make $600,000, on my tax return it's going to show 2. But if you actually lift the corporate veil, you'll see that my actual income is much higher than the 200,000. So again, it's not a black and white answer. It's a, where are your children living? Our child support, federal child support guidelines will say, if you have primary residence of the children, that means 60% of the time, then it's really, for basic child support, it's really only the non-custodial parent's income that's relevant. Your income's relevant for what's called proportionate sharing of extraordinary expenses. So childcare required for a parent to work, medical and dental not covered by insurance, orthodontics, for example. So if the parenting schedule is such that it's considered shared under Section 9 of the federal guidelines, child support guidelines, that means if you, and this is important if you're counting nights, 6 nights out of a 14-day period is considered shared parenting. And that's where you have to look at both parents' incomes. And so number one, figure out your parenting schedule first, because that will determine whether you're setting off child support or not. What that means is, if my income's $100,000 and your income's $50,000 and we're sharing parenting, so whether it's 50-50 or 60-40, then money will flow from the higher income earner to the lower income earner, just by virtue of typically wanting to have comparable lifestyles in each household. So money flowing from one house to the other house to equalize the standards of living a little bit more. So that's one thing. Then it's determination of income. If you have 2 people who are T4 employees, it's very easy to go online and Google federal child support guidelines or British Columbia child support guidelines. And there's a quick calculator there. So if you share parenting and your income's 100 and your partner's is 50, you put both of those incomes in, you've got 2 children, you put that in, and you'll have your amount, let's say it's, for simplicity's sake, $1,200 a month, and you'll have your spouse's, let's say, $550. And then so there's a bit of money that will flow. Very easy for you to do under the federal child support guidelines. Typically, child support is reviewed annually or on request of a parent if there's a material change in circumstance. Again, the requirement to disclose a material change, like a change in a job, of course, people will always disclose if they've lost their job or if their income's gone down. It's usually the opposite, where there's non-disclosure, where someone's income has increased. But simplicity is really for those people who don't have complicated sources of income, really the T4 employee. Then it's easy to determine what the child support amount is. But key first is to determine where the kids are.
Right.
The first thing I feel is really important for people to understand is we now have a regime in British Columbia that applies to common law spouses. That means you're living together in a marriage-like relationship for 2 years. A marriage-like relationship is, and whether you're in one, is sometimes unknown to people. It's based on a whole bunch of indicia. So what that means is you may think that because you have an apartment that you rent, that you never go to, that you have your own place and you're not in a marriage-like relationship. Where the person that you're with, whose house you're at, every night. You have a key to, you have a bank account, they use your credit card. They think that they're in a marriage-like relationship with you, despite the fact that you have this other apartment that you rent. And you're in that situation for 5 years, thinking that, oh, I'm just dating this person, we're not in a marriage-like relationship. And then you break up and you're served with a notice of family claim saying you've been in a marriage-like relationship for 5 years. And all of a sudden they're making a claim to half the increase in value of all of your property. And they're making a claim for spousal support. So before you get into a relationship, make sure that if you want to be in a marriage-like relationship, make sure that that's crystal clear. If you separate from your spouse, you are no longer considered spouses under the legislation that applies if you die. So everything that you've left to your partner in your will is no longer valid on separation. So that's just another important factor to know. People are always concerned about leaving the house. If I separate from my spouse, everyone tells me not to leave the family home. And I never really understood what that was all about. And the only reason, from my perspective, not to leave the family home is if you want leverage to make that person's life so miserable that they come to the table and give you whatever you want. But you have no less rights to family property just because you leave the premises. The two things you really want to make sure you've done before you leave would be to, if you've got children, don't just leave and don't just take them. And because then you're opening up Pandora's box to World War III, which means, you leave the house, you leave your little note that says, I'm off to my parents, I've taken the children, see you later. If you do something like that, that tells your spouse that you want to fight, and they're going to find a lawyer that will fight. Mm-hmm. And all of a sudden, you've spent $30,000 in legal fees that you weren't expecting. And maybe you made the decision to leave because you were afraid, or there's family violence, or whatever the case may be. But don't worry about leaving the family home. First, if you need to, and second, get your parenting plan organized before you leave, because then you'll know what your children are doing, and frankly, they'll know. Conflict is what impacts children. I've dealt with lots of children in my parenting coordination world where they're fractured, and they're fractured because of the conflict between their parents. And then you meet children whose parents have been through separation and divorce, who did it collaboratively or were amicable, and they don't even remember. They just know that they have a big family and two different households that they go back and forth to. So don't worry about the family home. If you need to leave, leave, and really try to get some advice before you do anything to make sure that you're doing it properly. Because the last thing you want to do is set yourself up for disaster and for your family.
So going back to point one about the marriage-like relationship, that brought up a few flags for a number of people that I know that are in marriage-like relationships that are already divorced and have taken big settlements from their ex-partners, and I said, you should get an agreement or whatever. How do you get, there's no such thing as a cohabitation agreement if that person lives in a different place. How do you protect your asset?
There have been occasions where I have done agreements confirming that people are not in a marriage-like relationship. And if they choose to be in a marriage-like relationship, that they will enter into a cohabitation agreement. But intention, if you don't want to spend money going to a lawyer and having to go down that road, and it's an awkward conversation, what you need is evidence of your intention and of your life, and conveying that to the other person, making sure other people in your world know that. But also, don't take the steps that are going to allow a person to argue that you are in a marriage-like relationship. don't give them your secondary credit card. Don't allow them to move their entire apartment contents to your house. Like, those are the things that you want to avoid. And if you're not sure, then get advice. Like, that $500 that you spend, or $400, or whatever the case may be, for an hour of advice from a family law lawyer will likely set you up for success and put you on the right path. But it's the scariest thing for me as well, is this idea that you didn't know you were in a marriage-like relationship.
Yeah. So, well, I mean, post-divorce, that seems to be the common thing. A lot of women and men are in committed relationships that many people say, oh, I'll never get married again, or I'm not going to live with anybody again. And to then find out that they've been in a marriage-like relationship because they've been committed, and that they're financially on the hook for that could be quite a shock.
Well, it's just a battle you don't want to.
It's not part of your financial plan.
It's not part of your financial plan, and it's a battle you want to avoid
for the future. Yeah, right? Absolutely. So as we talk about cohabitation and marriage agreements and that kind of thing, we're talking about what happens after you've gotten divorced the first time. If you have somebody who's cohabitated with somebody who's already divorced and has children with their first partner, and now we split up and I'm going on to partner number 3, or just to go live by myself, do I have to pay child support for her children?
So again, world of gray. And so the first obligation is always with the parents. So if adequate child support is being paid, then it's unlikely for the step-parent to become involved. But we do see cases where there are young children, and the bio parent, as it's often referred to, is not in the picture anymore. And the step-parent has stepped into the shoes of a parent. So they've financially supported the child, they've lived with the child, and then the parties separate. So the person who's left behind will then sometimes go after the step-parent for child support. And then often the step-parent will try to third party the bio parent, so to speak, for child support. So then all of a sudden there's 3 people in the mix. And sometimes, and it's often too bad, because the step-parent has built, oftentimes a meaningful relationship with the children, but now they're reluctant to maintain that relationship because their ex is demanding child support of some huge amount, or is saying, you're not allowed to see the children unless you pay me child support. So it can get really tricky. Mm-hmm. But again, another reason to have a cohabitation agreement. My clients often come to me and they say, listen, I went to my bank and I asked my banker what they needed for me to qualify for a mortgage. I'm going to be getting child support, but we've agreed to lump sum spousal support. And will I be able to qualify? And there are so many mixed messages out there for people. But what would you suggest is necessary for someone to qualify as far as child support, spousal support?
Well, it really comes down to the term of the child support and the spousal support. And also, a lot of lenders will look to see, is there other income? So does that person have, they generally like that the spousal support and the child support makes up, say, 30 or 40% of the income, but there is other income coming in. So should that ex-partner, who they know nothing about, would lose their source of income and not able to pay, that somebody would still be able to make the mortgage payments. That being said, there are situations where you can get approved on just spousal support and child support, because we do have the separation agreement. We've had situations where you can Google anybody. So say, for example, it's a prominent doctor or something like that. That person's going to continue to have their income paying through. There's not going to be issues with interruption of income, that kind of thing. But generally, it's going to come down to and how much they have down. Are they putting 20% down? Are they putting 50% down? So it's not a clear answer. I can't give you a clear answer on that, but there's always ways to get things sorted out. So if you get the lump sum spousal support, that can be good in terms of reducing the amount of debt that you have to pay, but is that child support going to be enough to cover all those other expenses and qualify for that? There's bank financing, there's alternative financing, there's pure equity financing, there's ways to get through it. I have a few clients that have started on the alternative side where they go in slightly higher than bank rates, and they're all very reluctant to do that because everybody thinks, oh, this is a bad mortgage. I shouldn't
take B lender.
A B lender.
Yeah.
I shouldn't be with a B lender because I have all these assets. But generally, within a year or two, with good coaching from your mortgage broker, you can get to the next level in terms of getting back into the bank. It really takes a period of time for you to get that. But if you were to pull out of the real estate market altogether, and of course, look at 2021 for an example, the real estate prices have gone up. If you had decided in 2020 that you were just going to wait until you qualified for that bank mortgage, well, look at that. You know you're not going to be able to now because the prices have gone outside of your affordability range.
I really do feel like the banks need to be better educated about sources of income, because my understanding, in part from you, Sabina, is that they'll often just look at your tax returns. And so many of my clients are business owners and are incorporated. And again, it's that lift the corporate veil concept, which the banks are not doing. And if my lifestyle is such that I only need, $200,000 a year from my corporation, but my income is actually $700,000, the banks won't look at that. They'll only look at what's on the tax return. So my own view is that there really needs to be a shift in the thinking of the banks to look outside those four walls, because they don't seem to do that. And that's what's so frustrating for lawyers who have high net worth clients, some of whom, and I'm usually talking about the spouse who hasn't necessarily had a lot of the income or the assets in their name or what have you. And it's complicated and it's stressful for them, and it's frustrating for us and for you, I'm sure.
Oh, very much so. I mean, back in the day, I've been in the business for 20 years, and we used to be able to use the corporate income. The corporation structure was set up to protect people that are not salaried, that did not have pensions, that they could save money in their corporations towards their retirement. That was the whole intention. It was started for doctors in Canada because we weren't paying as much in the US, and then also for lawyers as professionals, and then it expanded to basically self-employed. If you're earning more income, it makes more sense. Now, flash forward to the financial crisis, that changed things, and then governments changed. So it's not so much, and as much as I would love to throw the banks under the bus, it's across the board. It's federal government rules. So it's Bank of Canada, it's the Office of the Superintendent of Financial Institutions that have made the decision that if you're not paying taxes, full personal income taxes on that corporate income, they won't count it towards qualifying for the mortgage. The challenge for that is that nobody knew that. So the accountants were not informed that. The accountant's job is to make sure that their clients are paying the least amount of taxes as possible and using things like corporations to keep money in the corporation that they're not using. So it creates a double-edged sword in that sense. So
and that makes a lot of sense. I mean, when you say it like that, it resonates and it makes sense. It's just, it's frustrating.
Very frustrating, very frustrating. And the affordability is definitely there. If that person's making $700,000 and they're only drawing down $200,000, if they're going to be buying a bigger place, they're going to be taking some of that corporate income and drawing it down. And you can see from the historical financial statements that income is consistent. So there are ways to demonstrate affordability, but unfortunately, some of those things have gone out the window. So it's gone less from common sense to more like, we want taxation revenue and that kind of thing.
Right.
So when your clients are feeling frustrated with the bank, it's also a good opportunity for them to talk to their MP about situations like that and say, how are we going to fix this? Because Vancouver, Toronto, a lot of cities have become unaffordable, and we require a lot of self-employed individuals, especially in British Columbia, which does not have large head offices and large corporations here. Self-employed is what holds this province up, and the rules apply Canada-wide, so we're maybe the forgotten province over here.
Yeah, it's too bad.
Thank you so much for joining us, and thanks again, Nikki, for joining us today, and such a wonderful interview and so much great information that we got from you today, and I'm sure that our audience members really appreciate everything you brought to the table.
Thank you
so much.
And Sabina, thank you. You are the best at what you do, and I hope that most of, if not all of my clients end up at your doorstep looking for their new mortgage.
Thank you, Nikki.